I will now call 123-742 State v. Butler.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers. In this case, the defendant was convicted of 15 crimes after he held LK for 4 hours, held her captive, and repeatedly raped and sodomized her. But the Court of Appeals reversed his aggravated kidnapping conviction, finding there was insufficient evidence. It did so based on a misapplication of this court's opinion in State v. Burden, a just strange multiplicity analysis, and even if bugs were to apply, a misapplication of bugs. This court in State v. Burden very clearly stated when the state charges to inflict bodily harm or terrorize, the bugs test simply does not apply. That should have ended the Court of Appeals analysis right there. The defendant only asked for the bugs test. The bugs test didn't apply. The conviction should have been upheld. The court then went on I simply just don't even understand the analysis with the multiplicity, but regardless of what that analysis was, it is certainly not anything this court required in Burden. I think they said something about that the holding in Burden was implicit. It wasn't. I do not know how the court read Burden that way. I think that holding is non-existent. Then, even if whatever the multiplicity analysis was, it was the wrong multiplicity analysis. Multiplicity, if the crimes have separate or different elements, there is no multiplicity issue. Rape and aggravated kidnapping do not share elements, so no multiplicity. And even if you're unconvinced by anything else I just said and somehow apply bugs, despite the fact that Burden says bugs doesn't apply and no one has asked you to overrule Burden, the evidence even in this case was sufficient under the bugs test. Holding someone for 4 hours is sufficient. This court said as much essentially in Howard. And then I don't know why the court took issue with the rape being the bodily harm, because this court in Zamora said that rape is in fact bodily harm for the aggravated kidnappings.
Where do you think the panel, my reading of the panel's decision is that I guess that it was charged under A3, but then presented under A2, or maybe I said that backwards, but and I'm reviewing the record, and it appears to me that it was actually charged under A3. The instructions were under A3, and the closing argument by the prosecutor was under A3 as well. Where do you think the panel got to the A2 theory? Was it just that they thought it's a functional equivalent in this case, or?
I don't know. I read the panel as kind of saying, well, if there's a crime alleged, you have to go under A2, which is something that this court has certainly never said and didn't say in Burden. And in fact, because the elements are to inflict bodily harm or terrorize, we're almost always going to have some kind of crime. I mean, bodily harm is going to be battery, terror could be assault, numerous other things. But so I just genuinely do not understand what the Court of Appeals did here. It's hard for me to explain. There are no further questions. The state would just respectfully request that this court reinstate the aggravated kidnapping conviction. Thank you.
May it please the court, Carol Longenecker Schmidt on behalf of the appellant, Mr. Butler. Our argument today is that the bugs analysis applies. Briefing this case, I did not explicitly ask this court to overrule Burden. That is true. But I think that's implicit in my argument. Bugs has to apply to this situation. Bugs has to apply to crimes charged under subsection A3 because subsection A3 is the functional equivalent of subsection A2. Hold someone to inflict bodily injury is the same as holding someone to facilitate a crime.
So you're suggesting when the bodily injury constitutes an offense, a crime, then that's when it becomes a functional equivalent, and we should expand bugs to apply in those situations,
Yes, that is correct. That
which
is,
would require a reversal of Burden.
yeah, that is correct. And
But let's go back and look at bugs. What justifies bugs test?
in bugs, specifically that opinion,
Yeah.
or justifies it in my case here.
In bugs, what justifies the holding of bugs? That is not language found in the statute. Some argue it was a concern for multiplicity. It seems that if that's true, it was because bugs was decided in an era when this court was saying that it was pre-Schoonover, let's put it that way. And it was very difficult to understand the court's multiplicity analysis during that period. I think it was kind of all over the board. Sometimes they said you had to have unitary conduct, or any unitary conduct was made two crimes multiplicitous. Other times they did more of a Schoonover test. So how do we justify bugs even?
So my understanding of bugs is that it is this unique overlap of multiplicity analysis with sufficiency. So I think the bugs court was looking at the elements of kidnapping and trying to figure out what did the legislature mean by the word facilitate. And that surely facilitate meant something more than just the force inherent in the underlying crime, because the legislature likely did not intend, because if it doesn't mean something more than the force in the underlying crime, then you will have this multiplicity problem. You will have two crimes charged for identical conduct.
That's no longer our test. That was their test at the time of, sometimes their test at the time of bugs,
Sure,
but it's
sure.
not our test now.
Right, yeah, and so I recognize that. I think though, if you look at the three bugs factors that they lay out, those they do not perfectly line up with Schoonover, but they get at some of the same questions in the Schoonover test in the first element when you're trying to determine whether the conduct was unitary or discrete. So questions like the timing and fresh impulse and specific movement, factual questions about the incident itself, that mirrors bugs language of, well, the taking should not be, I don't have the language in front of me, but merely incidental to the crime. It needs to be independent somehow. It needs to have a separate significance. So my understanding is, or the way I make bugs mesh with Schoonover is that the bugs factors are analogous to that first step in the Schoonover analysis.
And even if there is a real multiplicity problem or perhaps a real merger problem, is it legally proper to force that into a sufficiency of the evidence analysis?
I'm not sure. I mean, my answer is yes, because again, it comes back to what did the legislature intend?
Well, we can just look at the statute, and if we do what we normally do, which is say jurors are capable of understanding ordinary words, and it should be up to the jury to decide whether this was a facilitation. We would say, well, there's certainly sufficient evidence for a jury to make this conclusion. We might throw the conviction out on other legal grounds. I mean, when we look at our other multiplicity cases or our other merger cases, we would never say, I mean, we would say a battery might merge with a killing, but we would never say, oh, but there's insufficient evidence to support the battery conviction.
Yes, I acknowledge this is a unique overlap of multiplicity and sufficiency.
I guess I'm just asking, given that, how can bugs stand, given that problem?
So, I mean, I think bugs needs to be clarified. And maybe it needs to be reframed as a multiplicity issue. Maybe the jury to address the question of, does the jury decide, can they decide facilitate, can they decide what a sufficient taking is? Maybe the jury needs to be instructed on the bugs factors. Maybe that's how, moving forward, we separate this, or we get away from the problem of all rapes becoming kidnappings.
And that seems to me the concern in bugs is that every rape, every robbery, maybe not every, but requires some sort of detention and movement. And that's what I think they were trying to distinguish is what is kind of the slight detention and movement, and converting every robbery, every rape and like crimes into an aggravated kidnapping. And I think that's the tension they were trying to address.
Yes, and that
I
does,
see that, but yeah, I'm not sure that's the avenue to do it, but I see that.
it does seem like that would be there is no hard and fast line. That's a factual question for the jury, but they need some guidance. And simply laying out the elements without explaining this distinction is going to result in multiplicitous convictions.
I think what Justice Stiegel is saying is, then we analyze it under multiplicitous conviction.
Yes. Yes, I acknowledge I don't have a good argument for why you should analyze it under sufficiency, other than that's what this court has done in the past. You know, and right, in Bugs, in Burden, in all these cases, that's the path that this court took. But it doesn't necessarily make my following or final sort of argument for why let me rephrase this. So why taking taking and confining must mean more than what's inherent in the underlying crime is what the Court of Appeals noted in its opinion, that if we're gonna just give those special criteria, just leave that for subsection A2, then we're going to, for lack of a better phrase, end up with an equal protection problem. We're going to end up with people who commit the same crime, and then the state can elect which subsection they charge under. And you'll have people committing the same offenses, and one set receives a more lenient standard than the other set. And so that cannot, I mean, it can, but that would cause inconsistency in charging and the application of standards to similarly situated people.
Under A3, to inflict bodily injury or to terrorize the victim or another, do you have a multiplicity argument there in this case? Or in any rape case, I guess. Because the elements are different, so there's not.
Okay.
So let me-
Okay.
When the same conduct.
Well, inflict bodily harm, and we've said rape is bodily harm.
I apologize. I'm not sure the question. Okay, yeah. So when we're talking about multiplicity, and this gets to the state's argument that sexual intercourse is the finding the different element there. My argument is coming back to this case law that says that rape, that in and of itself, rape by force, I guess, rape by force or fear, not other forms of rape, that in and of itself defines bodily harm. So if we're going to say that that is true, then that's not an additional element. I mean, I understand the exact wording of the statute is different, but I don't think the test are the words exactly the same. It's about what needs to be proved element
Can I ask a,
here.
not a strictly legal question, but maybe a big picture question? Why do you think it bothers us collectively, going all the way back to 1976 in Bugs, that every rape might be a kidnapping? Why is that so troubling?
Well,
That somehow unfair to defendants who
Yeah.
commit rapes?
yeah, all rape is bad. But there are some situations that I think feel, talking about feelings here, that feel especially bad. The isolating factor of moving somebody from public to private, confining them physically, that is above and beyond the elements of rape. And again, that's another argument for why.
Well, let me rephrase the same question with perhaps a little bit more legal overlay, which is, why couldn't the legislature say, we think this conduct is so bad that it is going to qualify as a aggravated kidnapping and a rape? And that's just the law of Kansas. What's wrong with that?
I suppose the legislature can define crimes how they wish.
And it appears to me that perhaps that's what they've done.
So the problem here is, so we're talking about rape in the situation, but subsection A3, bodily harm. And so are we also going to say that, is this true also for battery, for other types of bodily harm? Is the legislators also saying now that any force or movement that's inherent in committing this other bodily harm crime also, necessarily is kidnapping? I think that's the concern here. I mean, rape is at issue in this case, but there are other crimes. So that's my best answer to that.
Or isn't the concern really the concern of multiplicity, that you get charged for 2 crimes and punishment for 2 crimes for the exact same conduct?
Yes, that is the concern. I was imagining a scenario here where the legislator somehow wrote it so it was one statute, but yes, that is the ultimate concern, is a double jeopardy concern of yes, 2 punishments for 1 crime. So our request is that this court affirm the Court of Appeals, and at 30 remaining. At the remaining of my argument on the petition brief. Argument.
Chalmers, you reserve 3 minutes.
State would agree that State v. Bugs should be overruled. I think State v. Burden's the better test. It specifically says we're not going to read things into the plain language of the statute. I believe the state didn't ask that here simply because it wasn't the subsection at issue. But to the extent there is some conflict and this court is willing to overrule Bugs, I absolutely think that should happen. It should just be a pure multiplicity test. I don't think there's anything wrong with the legislator saying rape and aggravated kidnapping, if there's no multiplicity issue, can stand as 2 separate convictions. But regardless, here, again, the facts here were 4 hours. He held her for 4 hours, repeatedly raped her, repeatedly sodomized her, threatened her with bodily harm, took her car keys, took her cell phone. This is an aggravated kidnapping, and the Court of Appeals was wrong to hold otherwise. We respectfully request that the Court of Appeals be reversed.
Thank you, Ms. Chalmers, and thank you both, counsel, for your arguments. Court will now take this matter under advisement.